How can you succeed in prosecuting a case where a police officer is a victim when you have the deck stacked against you already? Your jurors don't like police officers and they're not going to convict.
We're here today with Nicole Castronovo, one of the talented attorneys from the RLS law firm. Nicole, I know you are a trial lawyer and a public safety advocate. You work for First Responders. We are really grateful to have you here. Thank you so much.
Oh, thank you for having me.
I know you've been working with Megan McCarthy, a former deputy and SEBA member who responded to a call for service, was almost executed, by the grace of God was not, and then just recently her attacker was found not guilty. Explain to me, what it was about this case that caught your attention.
This was a video that was taken of a police officer being absolutely brutalized and assaulted. And then reading about the trial and seeing that there had been no conviction, I looked further into this case. Just based off the video alone should be shocking. And then I looked further into it to see what the charges were. And it's just become more fascinating to me since then, because everyone's talked about the charges of which the man was acquitted: attempted murder, assault. But no one's been talking about the charges that the jury hung on, like the resisting arrest or removing a firearm from a peace officer. I don't know how you watch that video and a juror doesn't see that obviously the firearm's been removed from Megan and get a conviction on that charge. And so that really fascinated me as to what happened in this case. Why did we have someone who was assaulted, who was nearly killed, and no conviction?
It just seems so obvious in that video. How can something that seems so common sense go into the criminal justice system and then come out completely twisted? What are some of the things you think went wrong?
Some of the things that I think went wrong in this case started with jury selection. So now we have a new law in the state of California, AB 3070, which allows for jurors who are biased against police officers to stay on a jury. And it makes it nearly impossible to remove them from jury selection for an attorney to exercise what's called a preemptory challenge. And because of that, it really stacks the chips against a case where an officer is involved. And this now not only applies to criminal cases, but it's applying to civil cases. So where you have a police officer who is a witness, this can be difficult to have credibility towards them being a witness to a case. Where you have a police officer, in this case, who is a victim, it's difficult to get a conviction because bias was allowed against her. In a case even more frightening, which we haven't seen yet, but potentially a case where a peace officer is a defendant in a case, this law would be in clear violation of their due process rights because it allows for jurors to be biased against them and sit on their jury. You have a right to a fair trial under the Sixth Amendment, and it allows to have that violated.
This entire case and the aftermath, when I've heard some of the statements that have come after it, clearly I've sat and listened to Megan's story and grateful for the people who are helping her get her voice, like you and others. But then you hear these asinine comments by the defense attorney in that case.
The jury instruction that the court read to the jury basically says if you want to detain somebody, you have to have a reasonable suspicion that they're involved in criminal activity. And in this case, the issue was the initial detention of Mr. Young legal? If it's not, then he's not guilty. No matter, he could punch her 100 times and it wouldn't matter.
In California, you're allowed to resist. You're allowed to even hit a police officer, believe it or not, if they're not lawfully performing their duties.
He also says his client did not fire at the deputy.
This was an illusion.
Can you clarify the law in this case and why his comments are so dangerous?
So some of the comments that I've heard that are especially disturbing from the defense attorney in this case was along the lines of the defendant could have punched Megan 100 times in the face and not received a conviction. And that's absolutely not the case. Everybody has a right to self-defense if you're being wrongfully assaulted, harmed, but it's also a reasonable right to self-defense. And there was no unreasonable force used in this case. The video is just Megan trying to make a lawful detention of someone she had reasonable suspicion to believe was defendant in a crime or suspect in a crime. There was no excessive force used here. So there was no right by the defendant to strike Megan. There definitely is never a right to take a police officer's firearm. There is definitely never a right to take a police officer's firearm and fire at them. And there's definitely never a right to fire at someone who's unarmed and running away pleading for their life.
Right, or who's on the ground that you're on top of. Yeah, the self-defense has to be an eminent defense of your person.
Or others.
Or others, right?
Yes.
Yeah. And in where the video clearly shows, he has got the upper hand on Megan in that point.
He definitely had the upper hand. And as I've watched the video several times now, I think everyone focused on the defendant firing the firearm at Megan as she ran away. But when you watch the video and you first see them wrestling on the ground, you see him try to take Megan's weapon from her on the ground before he actually gets it. And you can see on the video him actually pull the light on her gun. In an attempt, you can see he's trying to pull the trigger on the gun and he activates her light. From the very get-go, when he was on top of her punching her, he was trying to shoot her with that weapon.
Yeah.
And clearly he had quite literally the upper hand on her, and he was trying to shoot her while she was on the ground. And then he proceeded to try to fire the firearm at her. It didn't fire, and then he cleared it and fired the gun.
The worst part about this is because that video, you look at it and it just seems like it's just common sense. And then this piece of evidence that is clear, at least to the regular person, what happened, goes into the justice system and somehow gets mangled, twisted up, and spit out into a whole different thing. You know, what are some of the reasons in your expert opinion that could be happening now?
How can you succeed in prosecuting a case where a police officer is a victim when you have the deck stacked against you already? Your jurors don't like police officers and they're not going to convict. I think the intent of the bill was to be favorable towards criminal defendants and to prevent bias. But I think some parts of the bill were not incredibly well thought out or contemplated, and how that they could actually damage a defendant's right in their own trial.
Having been in Sacramento now for 3+ years, advocating for our membership specifically, for the profession as a whole, it really blows my mind how quickly these bills are written, how short they are when you think about the ramifications that they have, and how it's just so easy for people, or for the legislators, not for people, not for the voters, not for the people who have to live with the consequences, but for the people who enact these bills, to just kind of say, oh, well, you know what, we'll work with the problems, we'll work them out as it goes along, we'll work out the kinks, you know, once this is enacted. And here you are looking at these, I mean, these jury instructions specifically say they can express a distrust or have a negative experience with law enforcement, which, okay. But then you can express a belief that law enforcement officers engage in racial profiling. I mean, this, I think you had said it in one of your interviews, to have a bias against a defendant, in this case Megan wasn't the defendant, but to have a bias that is un-American, that doesn't offer a fair trial in any way, shape, or form.
It's un-American, it's unconstitutional, it doesn't follow the Sixth Amendment right to a fair trial, it doesn't follow due process rights, both state and federal. It's sort of incredible, and that's why I say I don't think this bill was well thought out. The thing that's concerning to me now is, what do you do with this law now that it exists? And how many people have to suffer until this law is repealed? Right now, people are being tried as we speak in criminal cases, and these new rules regarding jury selection are affecting them. So they have to get convicted in order to appeal it and challenge the law. It's a scary thing. It's a scary thing. And, you know, this was supported by defense attorneys. It was opposed by prosecutors, but it's actually already, I'm a criminal defense attorney. It's affected criminal defense attorneys too. I just don't think that this law was meted out by the correct people who would be able to spell out what some of these other consequences could be that might outweigh some of the positive aspects that could potentially be there.
Sometimes being in law enforcement, we think, oh, criminal defense attorneys, they're on the opposite side of it. But you are a criminal defense attorney. You happen to defend officers in certain cases, you know, where they're acting in good faith and they've had charges levied against them. And of course, I'm not a lawyer. But to me, if there is a police officer, a first responder that is serving, you know, that is in that defendant position, and there's a jury that expressly can have a bias towards that person, it just seems like, I don't know. I don't understand how something like this gets through.
Part of this may have gotten through because for equal protection to apply, you have to be in a protected class, right?
Right.
And so some people might have been thinking, well, police officers aren't a protected class, so that's fine, but not really thinking about, we also have due process rights, right? You have a duty to, you have a fair hearing, fair trial. And this flies in the face of due process. So I think that because on its face, police officers aren't a protected class, I think that they didn't take the next step to think that through.
Right.
I think they looked at equal protection and didn't pay attention to due process.
And then, I mean, again, there's another portion in this bill that basically states, I mean, not having to do with police officers or anything, but it basically states that if a juror is confused, or if, a potential juror is confused or has unintelligible, statements when they're trying to be chosen, that they also can't be excused from the jury, that they need to be able to stay. That would give me pause for concern.
Of course, because as an attorney, as an advocate, I want to make sure that the jurors that are seated understand the law, that they can articulate an understanding of things back to me, that they're paying attention. One of the portions in this law says jurors can be inattentive and not be excused. That could be up and including to sleeping and not be excused from the jury. And how can I get a fair trial for a client if I'm talking to 12 people who are sleeping?
Thankfully, I think the sleeping language got struck, but the original versions literally had that a juror could be asleep and still not dismissed.
Yes.
It doesn't make any sense to me.
We have the law that is the law of the land. The well-established Supreme Court law is Batson Wheeler, right? That's the case law that attorneys refer to that says you can't excuse jurors solely on the basis of race, religion, creed, ethnicity, anything like that. And so we already have that in place. That already exists. So there really isn't a need for AB 3070. I think it was an attempt to elevate Batson Wheeler, but I think it's gone so far that it's actually going to be bad for criminal defendants across the board, whether they're civilians or police officers. I actually think it's a pretty dangerous law.
The California legislature seems to be intent on taking well-codified law and just adding their twist to it, which I think sums up kind of the theme of what we're seeing in the courtrooms, where they don't want to accept the law as it is. They want to have the law the way they want it to be.
Yes.
But in this case, you have a group of legislators that can actually make that happen to the detriment of the rest of the constituency.
And in my opinion, this law is unconstitutional and needs to be challenged.
I think of our SEBA members and everybody doing this profession, they just keep pushing forward. They just keep doing what they do. They do the job because they know it's the right thing to do. They do the job because, a lot of them have a calling. There's a bigger reason to do this job. And they keep pushing forward. But man, when you keep stacking things against them, it's like, at what point do we get some relief here in this profession, or just in terms of law? Just in terms of the rule of law.
And I really admire police officers who are able to do this in this current climate that we're in. It's not easy to do. I mean, you can be one call for service away from being, on the news tonight and not going home, or being on the news because you got involved in a use of force, and now your picture's being put out there and you're being put on trial, and people are coming to your home. I've had that happen to people, protesters coming to their home, death threats, all of these sorts of things. Like, this is a very risky job right now, both risky safety-wise and then risky freedom-wise.
I will say this, having RLS and attorneys like you who we work with so closely and use, we're grateful to have you, your advocacy, your expertise, and at least the commitment here at SEBA that we're going to keep pushing forward for our members and for this profession.
Even though there are these laws that are in place right now and changes in the law happening, we're still fighting. We're going to still keep pushing. We're not going to just let this go in the night. We're not abandoning you. We're standing firm beside you, even as these injustices occur.
We appreciate it. I'm going to speak for them. I appreciate it, and we definitely appreciate it. Thank you so much.
Thank you.